Hi, my name is Firdaus.
Hi, my name is Mohamed.
Hi, my name is Rashafina Adira binti Abdul Halim.
Hello, I am Marcella.
We are from Group 1.
And today, my group has decided to summarize the case of Muhammad Raihan bin Ibrahim and another versus the government of Malaysia and others. Well, talking about the parties involved in this case, it revolves around the appellant, in which the party who disagrees with the organization's decision, who is also known as a former pupil in Port Dickson Secondary School, and the respondent, in which the party who responds to the appeal made by an appellant, who is known as the teacher named Mrs. Hao Kan Yong.
This is an appeal case. In the previous court, before appeal, judge named Mr. Justice Ajaib Singh dismissed an appellant's claim because the judge believed that the respondent did the right thing. Even if it's true that the respondent did the right thing, then why this case has been appealed? Like, what exactly happened? Then what is the legal issue? Then what is the decision of an appeal court? So, let us know, shall we? So it all started on 15 March 1971 in Sekolah Menengah Inggeris Port Dickson, a class with 37 to 38 students in their agriculture class and was being monitored by a teacher named Mrs. Hao Kan Yong. Then, Mrs. Hao Kan Yong on that morning simply told to the students to line up and pick the agriculture tools such as spades, charcoal and baskets from the storeroom, then head or march to the vegetable beds. Then, the appellant named Muhammad Raihan Ibrahim was using a spade to raise his level of a vegetable beds. At the same time, next to him was Raja Aminuddin, was using a charcoal with a loose blade and 5 feet long. Remember that the charcoal was 5 feet long. So, the appellant asked Raja Aminuddin not to wield his charcoal yet until he's finished his work. But Raja Aminuddin did not listen to him on that time and he careless about it, so he continued his work. On the other hand, the appellant thought that he or Raja Aminuddin was listening to him, so he also continued his work. When the appellant and Raja Aminuddin was next to each other, doing their work at the same time, the charcoal with the loose blade suddenly struck on the appellant's head. So, before the accident, Mr. Hao Kan Yong, or the teacher, was sat under a tree which was 4 yards away from the appellant. But she not even focused on the class. So instead, she was resting under a tree and stared on the left of her side and not even focused on the class until she heard someone calling out her name. Then she turned her face into the direction of the voice. Then she saw the appellant was holding his head, bleeding. Then, the appellant sued Mrs. Hao Kan Yong because of her negligence was not focused in the class. Is that all? No. Mrs. Hao Kan Yong also did not specify which tools that can be taken. She just simply told everyone to line up and grab any agriculture tools and head to the vegetable beds for their lessons. During the court trial, Mrs. Hao Kan Yong did explain to the students that they should not be near one another as a safety measurements. Neither Raja Aminuddin or the appellant should not be where they were. Then, Mrs. Hao Kan Yong added that she did not see the appellant was there on the accidents. So during the cross-examination, she has been asked, why did she not see them? No response. Then, Mrs. Hao Kan Yong was being asked again whether her instruction is sufficient enough because she did warn the students to be careful and not fooling around with the instruments or the tools. Then she added that those who are using the charcoals must face each other and maintain a distance to 3 to 4 feet. But on the accidents, Raja Aminuddin and appellant was 3 to 4 feet and it was being measured accurately by Yong Hui Lin, who was one of the students and witnessed the event. But remember, the charcoal was 5 feet long. Therefore, the instruction is not completely safe. Lastly, Mrs. Hao Kan Yong admitted that it is her responsible to distribute the tools to the students on that morning. But she didn't do it, so instead, she let the students do their own way and finish their lesson as the best as they could. If she had distributed this, she would definitely know the loose blade of the charcoals and none of this will happen. So, let us know the legal issue, the decision of the courts and the relevant law of this case.
Moving on to the legal issue of this case. First and foremost, whether the defendant is liable for negligence, in which it can happen when one breaches the standard of care, unable to act in a reasonable manner, or even commit an improper act that can result in injury or even loss to another. This is due to the fact that the defendant owed a duty of care to prevent the plaintiff from being harmed. Secondly, the defendant had breached the duty of care when the defendant failed to provide proper standard of care. Third, there is definitely a close connection between the breach of the duty to care and the resulting injury. Other than that, there must be an actual physical or mental injury resulting to the injury itself as a result of negligence. Observing through the elements of negligence itself, it can be said that the defendant were definitely liable for negligence.
The relevant law that can be applied in this case is Educational Act 1961. Under this act, there are two sections, which are Section 9 and Section 10. Section 9 describes that the Minister of Education has the right to issue general direction on related to policies on education. Mrs. Hao Kan-yong should have given proper and complete instructions on how to use agriculture tools, as it is a dangerous tool and can be harmful to anyone who uses it. Next is Section 10, which describes that the Ministry of Education has the right to issue special directions to any member of the Central Board formed under Part 7, Clause 7 of the Act. The special directions can also be issued to the manager, the governor, or any member of a board or committee established by the Minister of Education under Section 26A, subsection 4. The special directions can also be issued to the worker, head of the school, or an educational institution.
This was an appeal against the decision of the High Court of Seremban, which dismissed the appellant's claim. However, the case was appealed in Federal Court of Kuala Lumpur. The Federal Court dismissed this appeal case. The court final decision was the respondents therefore negligent for failing to take all the reasonable and proper steps to prevent the appellants under their care from sustaining the injury, and that their teacher did not check the condition of the garden tools nor provided a safe system of holding the gardening class. The evidence of this case was examined under the degree of supervision depending on the circumstances of each case, such as the age of the people and what they were doing at the material time. If the teachers knows that the pupils are engaged in doing acts which likely cause injuries to themselves or their friends, the teacher under a duty to take steps to ensure the safety of the pupils at the material time. In this case, the court used the guideline given by the Ministry of Education as the safety measure to use which the regard of using agricultural tools, which is to maintain sufficient distance while working with the tools, to use proper tools, to use sharp instruments, and to maintain discipline. But the pupils were left on their own to take the tools from the storeroom. Neither Mrs. Hao Kan-yong nor any other teacher did distribute them to the boys, nor did she specify what tool each boy should take. However, in the previous cross-examination, Mr. Hao Kan-yong admitted that as a safety measure, either Raja Aminuddin or the appellant should not be where they were. The court questions the answers given by the defendant, as there is no clear explanations why at the time of the accident she was not looking at the Raja Aminuddin and the appellant. She was simply sitting under the tree. The court also questioned that the warning, which is to be careful and not to fool around, whether it is sufficient, because at the time the people were at a very young age. According to another pupils, Mr. Hao Kan-yong instructed that when using changkol, they must face each other and maintain a distance of 3 to 4 feet. The distance was obviously not safe as the changkol has 5 feet handle. The boys were simply left on their own devices with general instructions. The court also said that Mr. Hao Kan-yong was responsible for distributing the agricultural tools, but she did not do so in the morning, as because if she had done so, she have discovered the defect of the changkol, which according to Raja Aminuddin had a loose blade. Such changkol is obviously dangerous and should not be used in that morning, because when wielded in the air, it is not certain which way it would fall.
So that's all from us. Thank you for listening and bye bye.
The music up. I wanna fall. Yeah. It's good to be back. I am a good.